Today I'm going to talk about the trademark process. So I'm talking from search, which is a super important thing to do. You got to search and make sure that other people aren't already using the trademark you want, all the way through registration. And let's not get this twisted here. This is a long process. It can be anywhere from 6, 7, 8 months, a year, sometimes multiple years depending on the circumstances. Part of that is government wait periods, part of that is that you need to be using the mark a certain way, and part of it sometimes is strategy based on other trademarks out there that you're trying to avoid, or maybe they're going to abandon, or a bunch of different things. So the first step I mentioned in the trademark process, a trademark search. You always want to work with a professional and get a professional, comprehensive trademark search done. This search is going to reference all the trademark applications pending, all the registrations, and company names out there if it's a good one. Because what you need to do is make sure that if you're in the same trademark class with another business out there that has a trademark, and that name is very similar to your own, most likely a couple of things can happen if you move forward with a trademark application. One, trademark office is probably going to refuse that application because they're the ones in charge of making sure that people don't have identical brands out there, meaning that they don't have the same trademark for the same products or services. So if you apply, they're probably going to reject your application and you're going to be out, $700. I'll cover costs at the end, but it can get pricey, and then you just threw away some money because you could have avoided that by running the search and seeing that you didn't have a good chance at registration on the front end. Now, the second thing that can happen, arguably worse and arguably more expensive, is that if there's another company out there that has the same name for the same products and services, and they find out that you tried to file for a trademark application or that you're doing business with that same name, they could come after you for trademark infringement, and that can be quite pricey for sure. Now, the search, like I said, that's going to cover whether or not there's similar marks out there in the 45 different trademark classes. I cover classes a little more in depth in another video, but 45 trademark classes that group together different products and services. Classes 35 through 45 are for services specifically, and then 1 through 35 are going to be products. For instance, class 25, clothing, accessories, things like that. Class 45, legal services. Class 41, which is probably what I'd be covered under for these videos, is like video production and also educational content. Now, I get into this in the class video, but these classes have been around in their current format for a very long time, so they tend to be very broad in what they include, which makes being distinct in your trademark class pretty difficult. So that's part of this process, is running that search, seeing if you're distinct. Let's say that search comes back and you're the only one that thought of that name in that class. Hell yeah, let's go. Now the trademark application process happens. Trademark applications are going to cost you between $225 and $275 depending on which application you use with the USPTO. I'm a big fan of the reduced fee, the $275, because it allows you to do everything online, and they don't penalize you if you miss something in the application, or strategically you leave something out because you want to see if the USPTO will require that in your application. Now, more on strategy and applications in another video. But when you file that application, you're going to file it either as intent to use or use in commerce. I have videos on all this stuff, but intent to use is you don't use the mark yet in public. You don't actually have it on the products you're selling, or you don't have it up with your services for sale, and that's, you're intending to use it eventually. You file that application, and if it all goes through according to plan, you file later evidence of you using it publicly to finalize that intent to use application. Now with intent to use, it actually does come with an additional filing fee at that later date when you file that you're using it publicly. Or other type of application, use in commerce. That's when you're already using it in commerce publicly with your goods or services. Now you file that application, it doesn't even get reviewed for 3 months. The 3-month mark is where the examining attorney at the United States Patent and Trademark Office reviews your application and then says, oh, it's too descriptive, or nope, there's another mark out there that's too similar, should have run a search. Hopefully you avoid that if you ran your search. Or some other issue about your application, maybe they need you to disclaim a word. That just means you can't really use that word in your mark. More on that in another video. And there's a couple other small things that they might ask for. Maybe you need to submit another picture, or you need to give a better description of your products or services. But that 3-month mark is where they're going to have that conversation with you that you need to do X, Y, and Z. Now, if everything looks good or they issue something and you respond and everything's good, then your mark moves on to the publication phase. That's a 30-day period of time where the public can challenge your application. What that means is, let's say you filed, nobody else had an application out there, but there is someone out there that monitors the trademark office and they use a name super similar to yours that they just haven't ever wanted to register for whatever reason. And they notice that you registered and then they realize, oh man, if they get the registration, then they have rights to this even though I've been using it since 1980 and I should have stronger rights. Well, they can file a challenge and challenge your application. And if they challenge it and they win, then you can't actually register your mark because the USPTO agreed with their challenge that they would be harmed by the registration of your mark. I have videos on what you can use to oppose. There's a bunch of different grounds. Sometimes you can even allege something as significant as the person that filed alleged that they actually committed fraud on the USPTO. Can get crazy. It's like a mini trial. But that opposition period, 30 days, if you get through that successfully, then the application will ultimately mature to registration. You're all good. You've done everything you need. Unless you need to file that other photo like I talked about, then you would do that at that point. And then that's finalized. But once you get through publication, should be smooth sailing, should be registration, all 50 states. You can protect your trademark, and the USPTO gives you an official certificate with a little gold emblem stamp on it, and you are official like a referee with a whistle. And that, like I said, gives you rights in all 50 states for your trademark, for your brand name, both to tell other people if they try to claim you're infringing, no, you're wrong, my mark registered with the federal government, or if somebody else out there starts using your mark trying to piggyback on your goodwill, you can go out to them and say, I have this registered, you have to stop or you're going to get in a lot of trouble and it's going to be very expensive. Now, more in-depth topics on all of these in some of my other videos, but I hope this was helpful for the overall trademark process. There are some renewal dates after you do achieve registration, 5-6 year mark. Covered another video. Check that out. Hope you have a great day.